I did not look at him when he walked in. I heard the door, heard the familiar drag of his left foot, a habit he'd had since his knee surgery 3 years ago, and I kept my eyes forward. The courtroom smelled like old wood and recycled air, the kind of place where people brought their worst days and laid them out on a table for strangers to sort through. I had been sitting in that chair for 40 minutes already. I knew every crack in the wall in front of me. My brother sat down at the plaintiff's table. He adjusted his jacket the way he always did when he wanted to look more important than he felt. I didn't turn around. The bailiff called the room to order, and Judge Patricia Hale, I would learn her name that afternoon in a way I will never forget, settled into her chair and looked out at us with the particular stillness of someone who has seen every version of every story. I was 31 years old. I was being sued by my own brother for embezzling from our father's estate. Let me back up. My father died in October, 14 months before that courtroom morning. He died the way he had lived, quietly without much fanfare, in the house he had owned for 34 years in Bozeman, Montana. He had been a mechanical engineer for most of his career, then a contractor, then semi-retired, then fully retired when his hands started giving him trouble. He was not a wealthy man by any measure people in cities would recognize, but he had been careful. He had a savings account, a small investment portfolio, a life insurance policy, and the house, which had appreciated considerably since 1989. When it was all totaled, the estate came to a little over $400,000. He left it to my brother and me equally. That was the problem, according to my brother. My brother, 4 years older, with a wife named Terry, and 2 kids in middle school and a landscaping business that had been almost profitable for the better part of a decade, had decided, somewhere between the funeral and the reading of the will, that I did not deserve my half. His reasoning, as it was explained to me first through text messages and then through a certified letter from a lawyer I'd never heard of, was this. I had spent the 2 years before my father died living in the house with him. I had taken time off work. I had access to his accounts because he'd added me to them when his hands made it hard to manage the paperwork himself. And during those 2 years, according to my brother, money had gone missing. Specifically, he claimed I had transferred roughly $60,000 out of my father's accounts and into my own. He was not entirely wrong about the transfers. He was completely wrong about what they meant. I am a logistics coordinator. That is what my LinkedIn says, and it is technically true, though it describes maybe 30% of what I actually do. I have worked for the same federal contractor for 6 years. The work is detailed, involves a significant amount of travel, to places I am not allowed to name in casual conversation, and pays considerably better than my brother had ever assumed, because I had never told him what I made, and he had decided on his own that the answer was not much. I drove a used Subaru. I wore the same 4 pairs of jeans in rotation. I did not own a home because I was rarely in one place long enough for it to make sense. To my brother, these were signs of financial struggle. To me, they were signs that I had different priorities than he did. When my father's health started declining, it was his heart, a slow and stubborn deterioration that the doctors had seen coming for years. I took a leave of absence and moved back to Bozeman. Not a full leave. My work does not entirely stop when I am elsewhere. But I was home, and I was present, and for 22 months I was the one managing his medications and driving him to appointments and sitting with him in the evenings when the house got too quiet. My brother visited 4 times. Terry came twice. They sent a fruit basket at Christmas. The $60,000 my brother accused me of was money I had transferred into my father's account, not out of it. Contributions. Grocery runs, utility bills, the medical equipment insurance wouldn't cover, the home health aid we brought in for the last 4 months because I couldn't be there every single hour. My father had not wanted to use his savings. He had been stubborn about that. Deeply, frustratingly stubborn. And so I had covered the gap myself, and I had not told anyone because I knew exactly how my brother would receive the information, and I did not want the argument. I had the records. Every transfer, every receipt, every invoice from the home health agency. The problem was that my brother had filed first, and he had a lawyer, and the lawyer had constructed a narrative from the bank statements alone, the raw numbers, without context. And that narrative was that I was a thief. The lawyer's name was Aldrich Beaumont. Mid-50s, silver cufflinks, the particular confidence of a man who has won enough cases to believe winning is his natural state. He had a way of pausing before he spoke that was clearly practiced, designed to make everything he said feel measured and significant. He approached me with the ease of someone who had already decided the outcome. "Ms. Vance," he said. "That is my name, Catherine Vance, though most people call me Kate. Can you tell the court when you first received access to your father's bank accounts?" "July of 2022, I said. "And can you tell the court how much money was transferred between your father's accounts and accounts in your name during the period between July 2022 and October 2024? "Approximately $63,000, I said. He let that number sit. He turned slightly toward the jury. 8 people, all from Gallatin County, all strangers to me, and let them do the math themselves. $63,000, he repeated. "And your position is that this money was not taken from your father. Is that correct?" "My position is that the direction of the transfers is the opposite of what you're suggesting," I said. "The money moved into his accounts, not out." Aldrich smiled the way people smile when they think they've already won. "Ms. Vance, the bank records your brother submitted show transfers between shared accounts. Are you suggesting those records are inaccurate?" "I'm suggesting they're incomplete," I said. "The complete records," he said, "will be reviewed by this court. But first, perhaps you can explain to the jury what you do for a living, because I've looked, Ms. Vance, and I cannot find a single employer of record for the past 6 years. No W-2, no 1099, no verifiable employment history whatsoever. So either you are hiding $60,000 you took from a dying man, or you are expecting this court to believe you earned that money somewhere no one can verify. Which is it?" I looked at him. Then I looked at the back of the courtroom. My attorney, a woman named Dale Osborne, who had the permanent expression of someone doing long division in their head, had told me this moment would come. She had told me to stay calm. She had also told me that she had sent a letter 3 weeks ago to a specific address in the D.C. metro area, and that if everything went the way she expected, we would not need to use what was in my personnel file directly. We would only need to make it available. I had asked her what that meant. She had said, "It means let me handle the documents." I said nothing to Aldrich Beaumont. I turned back to the front of the courtroom. The thing about my job that most people don't understand is that it is, in most respects, invisible by design. I don't have a standard employer of record because my actual employer is routed through a contracting structure that, for reasons I am not going to explain here because I was asked not to, does not appear on consumer-facing employment databases. I file taxes. My taxes are filed through channels that require a specific kind of clearance to access. When Aldrich Beaumont's paralegal ran my name through the usual databases, they found nothing, which is exactly what they were designed to find. I had known when my father got sick and I came home that I was taking a risk, not a financial risk. I had enough saved that 2 years away wasn't going to ruin me. The risk was exactly this: that my absence from visible professional life would be used against me by someone who needed a story and found my blank spaces convenient. I had not expected it to be my brother. He sat at the plaintiff's table across the room and did not look at me during Aldrich's questions. He looked at his hands, or at the jury, or at some middle distance that seemed to require his full attention. We had grown up in the same house. We had shared a truck in high school. When his first kid was born, I had flown back from a job in the middle of a situation I cannot describe and held that baby in the hospital hallway, while my brother cried from exhaustion and relief. I thought about that a lot in the weeks before the hearing. I thought about the fact that I had done all the things a person does when they love their family, quietly, without announcement, and that somehow the person who benefited most from my discretion was now standing in a courtroom accusing me of theft. There is something uniquely clarifying about betrayal by someone you loved straightforwardly. Dale cross-examined my brother for 45 minutes. She asked him, gently but precisely, how many times he had visited our father in the final 2 years of his life. She asked him to name the home health agency my father had used. She asked him if he knew what our father's monthly medication costs had been. She asked him if he had contributed financially to our father's care at any point. He said he had sent money twice. Dale asked for the amounts. He said he wasn't sure exactly. Dale showed the bank records, which reflected 2 transfers totaling $800 over 22 months. She asked him if he was aware that his sister had been contributing to their father's care expenses. He said he had not been given any evidence of that. Dale said, "So when you filed this suit, you were relying entirely on the bank records showing shared account transfers, without investigating the directionality of those transfers." He said his lawyer had reviewed the records. Dale said, "The records your lawyer reviewed, Did those records include the external transfer receipts your sister retained? He said. I don't know what records she has. Dale said, we'll discuss that. She walked back to our table and picked up a folder. My father had been, and I say this as someone who spent 2 years watching him, struggle with a body that was giving out while his mind stayed sharp. The most methodical person I have ever known. He kept paper records of everything. Not because he didn't trust technology, but because he had grown up in a house where the power went out in winter, and he believed that anything that required electricity to retrieve was only conditionally yours. He kept a ledger. Actual handwritten ledger, the kind with green-tinted columns. He had kept one for the last 30 years of his life, and in it he recorded every significant transaction that touched his accounts, including, in the last 2 years of his life, every deposit I made on his behalf, annotated in his handwriting. From Kate, medical supplies. From Kate, October home aid invoice. From Kate, propane November. My attorney had that ledger. She also had the receipts I had kept. I had kept them partly out of habit, partly because my job has trained me to document everything, and partly because some part of me, even at the time, understood that I was in a situation that might one day need to be explained. And she had something else. Aldrich had rested his case with a confidence I found, at the time, genuinely unsettling. He had built a clean story from incomplete information, and clean stories are persuasive. The jury had listened to him describe a daughter who moved back home, gained access to her father's money, took $60,000 over 2 years, and then collected half the estate on top of it, all while maintaining no verifiable employment. It was a reasonable story if you didn't have the other half of it. Dale stood and said, Your Honor, before we present the defense's primary documentation, I need to flag that one exhibit requires a brief procedural matter. Judge Hale looked at her over the top of her reading glasses. What kind of procedural matter, Counselor? A question of classification, Your Honor. Dale set a sealed envelope on the table. It was not dramatic in appearance. Standard legal envelope, sealed with tape, marked with a series of numbers I recognized and no one else in the room would. I have a document that speaks directly to my client's employment history and financial standing. It was provided to me through proper legal channels. However, it carries a designation that limits who in this courtroom is authorized to review it without a prior clearance verification. Aldrich was on his feet before Dale finished the sentence. Your Honor, this is a delay tactic. Counsel is attempting to introduce a document she knows cannot be examined by opposing counsel. It can be examined by anyone with the appropriate clearance, Dale said, perfectly even. I'm simply noting that we may need to take a brief recess to verify who in the room meets that threshold. Judge Hale held up one hand. Aldrich stopped. The judge looked at the envelope for a long moment, then she looked at Dale. Counselor, are you representing to this court that this document is what you appear to be representing it is? Yes, Your Honor. Another pause. The judge reached up and removed her reading glasses. She set them on the bench in front of her. She looked at the envelope again, and then she looked at me, and I saw something shift in her expression. Just slightly, just for a moment, the specific look of someone recalibrating a situation they thought they had fully understood. We'll take a 20-minute recess, she said. Plaintiff's counsel, defense counsel, in my chambers. I sat alone at the defense table for 20 minutes. One of the jurors coughed. Someone near the back of the gallery murmured something and was quietly shushed. The court reporter stared at her keyboard. I looked at the wall. I had not wanted any of this to be public. I had not wanted the hearing at all. I had offered my brother, in writing, through Dale, a full accounting of every dollar I had spent and every dollar I had deposited, with supporting documentation if he would agree to mediation. He had declined. His lawyer had declined on his behalf, with a letter that said, essentially, that they were confident in the merits of their case. The confidence of people operating on incomplete information is a very specific kind of tragedy. When the judge returned, Aldrich Beaumont was no longer smiling with his eyes. He was smiling with just his mouth, which is a different thing entirely, the kind of smile that happens when the muscles haven't caught up to the new information the brain is processing. Judge Hale settled into her chair and said, without preamble, This court has reviewed the document submitted by defense counsel. In light of its contents, I'm going to ask the jury to step out while we discuss the evidentiary implications. The jury filed out. The door closed. The judge folded her hands on the bench. Ms. Vance, she said, I want to be precise about what I can and cannot say on the record at this juncture. What I can say is that the document I've reviewed establishes, with federal verification, that you have been continuously and substantially employed for the past 6 years in a capacity that your employer, for reasons of operational security, does not publish through standard channels. It also establishes your income level, which is, she paused, considerably higher than the amounts in dispute in this case. The room was very quiet. Plaintiff's counsel, the judge continued, I'll give you a moment to consult with your client. Aldrich and my brother stepped into the hall. Through the door I could hear, not words, but the specific rhythm of a conversation where one person is delivering news and the other person is struggling to receive it. Dale sat down next to me. She had the controlled expression of someone who had played this exact scenario out in their head many times and was now watching it happen in real life with the same kind of focused calm she had probably used in law school moot court. You okay? She said quietly. I've been better, I said. She nodded. It's almost done. My brother came back into the courtroom and sat down at the plaintiff's table. He did not look at Aldrich, he looked at the floor, and then, for the first time since the hearing began, he looked at me. I held his gaze. There are things I wanted to say to him, in that moment. Things I had been composing and recomposing in my head for 14 months. Ever since the certified letter arrived with a law firm's return address, and the specific sick feeling that comes with understanding that someone you love has decided you are their problem to solve. I wanted to tell him that I had given 2 years of my life to our father without asking for anything. I wanted to tell him that I had sat in that house on nights when the wind off the mountains rattled the windows, and my father was asleep and I was exhausted, and I had not called him because I already knew he wouldn't come, and I had simply done the next thing that needed doing. I wanted to tell him that the $60,000 was nothing. Not because I have money to burn, but because my father was worth it, and the fact that my brother had looked at those numbers and seen theft instead of love was a thing I was going to have to carry for a long time. I did not say any of it. The judge reconvened. Aldrich stood and, in the careful language of a lawyer who has been told privately that his case has no remaining foundation, moved to voluntarily dismiss the complaint. The judge granted it. Outside, on the courthouse steps, it was one of those Montana October afternoons that feel like the weather is trying to apologize for something. Cold and bright and clarifying, the mountains doing their impassive thing on the horizon. My brother caught up with me at the bottom of the steps. Terry was still inside, or not present at all. It was just him. Kate, he said. I stopped. He stood there for a moment with his hands in the pockets of his jacket, and I could see him trying to find the right shape for whatever he needed to say. My brother is not a cruel man. I want to be clear about that because it matters. He is a man who was afraid and looked for a simple explanation and found one that was wrong, and then compounded it by hiring a lawyer instead of making a phone call. I didn't know about the money you were putting in, he said finally. I know you didn't, I said. You could have asked. He nodded. He looked at the mountains for a moment, the way people from Montana look at mountains when they need a minute. Why didn't you tell me? He said. When you were out there, why didn't you just call and say, hey, I'm covering some of this? I thought about that. I had thought about it before. Because you would have argued with me about it, I said. And I didn't have the bandwidth to argue. I was busy. He was quiet, and honestly, I said, I didn't think I needed to explain myself to you. Dad knew. That was enough for me at the time. He pressed his lips together and looked at the ground. I'm sorry, he said. It came out simply, without the scaffolding people usually build around apologies to protect themselves. I believed him. I also believed that sorry is the beginning of something, not the end of it, and that there was a long road between where we were standing and wherever we would eventually land. Apologies don't unfile lawsuits. They don't give back 14 months of dread. They don't make the certified letter disappear from your memory. But my father loved my brother. Whatever my brother's faults, my father loved him, and that meant something to me. It meant I was at least willing to find out what the road looked like. Go home to your kids, I said. We'll figure the rest out later. He nodded. He walked back up the steps toward the door. I had parked 3 blocks away. The walk back felt longer than it should have. The way walks always feel longer when your legs are still operating on adrenaline that has nowhere left to go. I sat in the car for a while without starting it. The document Dale had submitted, I'm not going to detail what it contained, for reasons that should be obvious. What I can say is that it established cleanly and completely that for 6 years I had been doing exactly what I told Aldrich I was doing. Working in operations in a capacity that doesn't publish, in a field where discretion is not optional but structural. The income records it contained were, in the judge's words, considerably higher than the amounts in dispute. The implication being that a person earning what I earn does not need to steal $60,000 from her dying father. The implication being that the entire foundation of my brother's case was a story he told himself, because he didn't have enough information to tell a more accurate one. I had not wanted it to come to this. I had wanted receipts and a ledger, and two adults having a conversation. But the one thing I have learned, in 6 years of work that requires me to operate in situations where I cannot explain myself and must simply proceed. The one thing is that you cannot control what other people decide to do with their fear. You can only be ready when the moment comes. I had been ready. I started the car. The mountains were still there, doing what they do. My father had looked at them every morning for 34 years, from the kitchen window while the coffee brewed. He had not been a sentimental man, but he had stayed in that house his whole life, and I understood now, sitting in the parking lot 3 blocks from the courthouse, where his estate had just been defended and my name had just been cleared. That staying was its own kind of statement. I had some decisions to make about what came next, but that was tomorrow. Today I had done the thing that needed doing, that had always been enough.